give the floor to Professor Vicky Kemp for her presentation. So Professor Vicky Kemp is a Principal Research Fellow in the School of Law and co-director of the Criminal Justice Research Center in the University of Nottingham and member of the International Legal Aid Group. She is also a member of the Lord Chancellor's Expert and Advisory Panel for the Independent Review of Criminal Legal Aid, and throughout her career, she has been involved in criminal legal aid as a paralegal, as policy advisor, and also as a researcher. So, Vicky, the floor is yours.
Thank you very much. I'll just try and get my screen up. There we go. Does that come up okay?
Yeah.
Super. Thank you very much.
Maybe.
Yeah.
It's loading. Yeah, it's perfect.
Excellent. Thank you very much. So thank you very much for inviting me today. I think this is a really interesting and important conference. So thank you. These are the issues that I want to address, and I'll get straight on. Child-friendly justice. I'm sorry to say, I think I'd call it injustice within England and Wales. We've had the Police and Criminal Evidence Act for 35 years now, providing legal safeguards, which include access to free legal advice for all suspects, which is really important. But whether someone's aged 10 or 60 years of age, there's no difference in how they're told about their legal rights. The same words are used. There is a mandatory requirement for an appropriate adult to be involved with all children aged 10 to 17 years, but PACE prefers that that's mum or dad. We do have a one-size-fits-all, and I'm sad to say that our minimum age of criminal responsibility stays at 10 years of age, and as Tom says, that should be at least 14 by now. We don't at any time have a mandatory requirement for a lawyer to be involved, irrespective of how young the child is or how serious the offence. Clearly, if a case goes to court, there's the safeguard of the judge looking at what's happening and can render the evidence inadmissible. But you do have a lot of children going through and getting out of court disposals, criminal sanctions. They can be put on the sex offenders register with no review of these decisions being made. What we find that is that children aged 10 to 13 years, they're least likely of all age groups to request a lawyer, probably because mum and dad are acting as the appropriate adult and don't see the importance, and a moral approach seems to be adopted. But they are in an adversarial system, and we find that they get worse outcomes than 16 to 17-year-olds who do have a lawyer, where there's far fewer cases where no action is taken. So how do we actually explain to children, particularly younger children, what their legal rights are in an adversarial system of justice? How do you explain what a lawyer is? What do they do? How can they help you? How can you get that concept across to such young children? It's my belief that we need to hear the voice of the child in order to influence change. In terms of a child's perspective on being a young suspect, I think it was 20 years ago an academic said that children are all but invisible in research into the criminal justice system. Little has changed. We've had a good research 20 years ago from Neil Hazel and his colleagues. I've interviewed 38 young suspects recently. More importantly, from Miranda Bevan, who looked into this issue as part of her PhD thesis, has done an excellent study involving 41 young suspects. Well, we've got information. We're talking to children after they've come out of custody, after they've stopped being a young suspect, when their memories have faded. But what do we know? We know that they do not understand their legal rights. They don't understand what's happening in this process. They're confused and frightened. They complain of oppressive police questioning. They get repeat questions when the police don't like the answers put forward. They're under pressure to respond to the questions and also to make admissions. In this adult-centered adversarial process, I believe that children are not in a position to participate and influence decisions made about them as required by the convention. Talking to them, and when they go into custody and there's a risk assessment, they sometimes won't mention really important issues such as having mental health problems or feeling suicidal, because they don't know what the police are going to do with that information. The process is not child friendly. But the question is, how do we bring about change? I'm delighted to say that we've got the Nuffield Foundation funding a project for us to examine the impact of PACE on the detention and questioning of young suspects. This is the first time in England and Wales that researchers will talk to children about their legal rights and their needs while they're held in police custody. This is important because we need to know, after they've been held for many hours in a cell with a priority to get out as soon as possible, how does that influence what they have to say in the police interview? What do they understand to be their legal rights? How do they exercise those rights and why? It's very sensitive going into police custody and talking to children who are so vulnerable, and recognising this and recognising important ethical issues arising. These research interviews will only be conducted by my colleague, Leslie Laver. She's a legal psychologist, a registered intermediary, and a trained appropriate adult. Leslie completed a detailed ethics application, ran into 84 pages. It included protocols and how to obtain informed consent for a vulnerable child while they're detained to participate in the research, to address safeguarding issues, and also on COVID-19. We have been granted ethical approval to proceed from the University of Nottingham and also from our police partners. We're ready to go ahead, but being held back at the moment due to the pandemic. I've been involved in researching police station legal advice for over 2 decades, and I'm convinced that it's only by viewing the criminal process through the lens of a child will we be able to bring about a child-friendly and child-centred system of justice. And this brings me on to what could be the role of legal aid, the role of the lawyer in helping to bring about change. We're adopting a mixed method approach, and part of that is to undertake case studies. These will focus on the police interview, and we will then talk to all those involved, the police, the lawyers, the appropriate adults, and most importantly, the child, examining those safeguards from the different perspectives. We'll explore what impact we think defence solicitors could have on helping to bring about change and adopting a child-friendly approach. Many years ago, and at the time that PACE came into force, I was a paralegal for a number of years. I provided police station legal advice. When talking to clients at that time, I wouldn't only talk about the alleged offence, but also what was happening in their lives. What were their needs? What were the problems? I'd take a detailed statement, and this was there to help the lawyer, to help influence decisions or to put mitigation later on at court. At that time, PACE was intended to involve lawyers to provide an important check and balance on police powers. They were intended to be in police custody, ready to talk to their clients. But since 2008 and a payment of a fixed fee, and this being insufficient to cover that work, many lawyers tend to just concentrate on the interview. So following a request, it can be many hours before they actually talk to their clients. Importantly though, and I know this from my own experience, lawyers have to build, and we've heard about it today, they have to build a relationship of trust with their clients. This is helped by having legal privilege, by being able to have confidential discussions. So they can find out really difficult and sensitive issues about vulnerabilities. Does their client have autism, mental health problems? Have they been abused? This is really important information that can assist decision-making when a child's brought into custody. A custody sergeant has to decide whether to authorise detention, and a lawyer having an input into that decision-making could really help. And at the very early stage of actually being brought into custody, that could help to identify opportunities for diverting them out of the criminal process, or to provide additional safeguards or adopting a problem-solving approach for those who remain. We also have liaison and diversion officers in police custody, and they could help by actually going out into children's services. Are the children known to social services? Are they looked after children? Have they been excluded from school? What other information could be brought in to help that decision making? Another issue is about assessing vulnerability. Well, you may have, you do have an assessment made when someone's brought into custody. A lot of our interviews by the police now happen on a voluntary basis. The child isn't brought into police custody. It's an interview under caution, and they have the same PACE safeguards. It's mandatory to have an appropriate adult, and they have free access to legal advice. So what I would like to see, and this doesn't happen at the moment, I'd like to have another assessment. I'd like to have an assessment of the fitness to be interviewed. And I think this should take place prior to police interviews with children, because this is actually the gateway into the criminal process. Once you go into that police interview, you're swept along into that process, and it's very difficult to get out. So I think, bearing in mind how important that police interview is, we ought to have an assessment. It can look at diversion, have children's services come and raise certain issues that could argue why a child should be diverted at that stage. And I don't believe the interview should proceed until that assessment has taken place. Lawyers should have a role in that assessment, both in custody or in voluntary interviews. They can comment on the child's understanding of their legal rights. There's a modified right of silence in England and Wales, and most adults don't understand what that means. If a child doesn't understand, should it really proceed, or should there just be a simple right of silence? Other issues could be raised, and we could look at opportunities for diversion when adopting a problem-solving approach. If the child is to be interviewed, I think at that stage, then we need to take into account communication and language skills of the child to help them give their best evidence. Effectively, if they go through to court and to trial, that's the first day of the trial. What they say in that police interview is really important, but it can also have other consequences and lead to criminal sanctions. We do have an assessment of achieving best evidence when dealing with vulnerable children as witnesses or victims. The police interviewers have to be trained to conduct those interviews, and a registered intermediary speech and language therapist can be involved to provide support to the child. Why isn't there a requirement for young suspects? The police don't have to be trained. Children are interviewed on exactly the same basis as adults. And I just don't understand why, when we accept that children as witnesses and victims are different and they need that support, that child suspects too shouldn't have that. There are issues of training and costs. I think we've heard about this from people, that really specialist training is required of all those involved with young suspects, including defence lawyers, and as the convention requires. This needs to include multidisciplinary training on the content and meaning of the convention, and what's required to ensure effective participation of the child. And practitioners also need training on neuroscience findings to understand what communication assistance children require. This is asking a lot of legal aid lawyers, and I think that we would need additional funding, additional legal aid funding to front load cases. And I think that would enable specialist youth lawyers to take on this far more detailed role. I think, though, by increasing opportunities for diversion, adopting a problem-solving approach and reducing reoffending, there is the potential for significant savings to be achieved within the wider criminal justice system. In terms of child-friendly justice, and as part of the Nuffield Foundation project, you've got a notice of rights when you go into police custody. It's a long list of your rights and entitlements. Children don't read this, many adults don't read this. So what we're trying to do is to create child-friendly ways of talking to children and young people, creating animations and interactive videos to inform them of their rights, to test for understanding. Having gone through the process, we can ask, do you have to answer police questions? If somebody says yes, they haven't understood their right of silence. I think a key message in those digital resources could be to have a lawyer, to make it almost mandatory. It's an opt-out rather than opt-in approach. What we know is that appropriate adults, if they're involved and they're trained, they will insist on having a lawyer. It's mum and dad who don't know the importance of this. So why shouldn't we require that mum and dad, that they should know, and there should be an assumption on the part of the police that a lawyer will be involved and they can arrange this. We'll be looking at developing digital resources that can help practitioners, the police and the lawyers and the appropriate adults communicate more effectively with children about their rights. Leslie Laver and her colleagues are looking at developing a digital assessment of vulnerability. This could assist the custody officers in carrying out assessments, both in police custody and in relation to the fitness to be interviewed. What about issues of suggestibility that need to be addressed for that child? We believe that adopting a child-friendly approach will certainly raise questions about continuing with an adversarial system of justice when it comes to dealing with children in trouble with the law, particularly when they're so young. And this is really important for us. And in terms of child-friendly resources, what I want to share with you, this is a mock-up of a website. We've actually set up a Know My Rights website for suspects, which again is quite text-based, it's quite top-down. But on this basis, what we want to do is to have a child-friendly version. You can see here that the key issues are always get a lawyer. Interviews are serious. They think voluntary interviews are often just a chat, and don't speak without having legal advice. We also want a button that says get a lawyer. And although we haven't got the facility to do this at the moment, there's no reason why they can't press a button, and that can go through to a call centre that tells them who the duty solicitor is, and they can get a lawyer that easily. Thank you very much.
Thank you, Vicky, for your presentation. Thank you very much indeed. Child-friendly material and material who help professionals to explain to children what are their rights and help informing children is very important. Indeed, in the framework of the LA Child Project, we will also develop the guidelines. The first guideline will be developed for authorities and legal aid professionals, but we also want to develop a material for children. Does any panelist have question for Professor Kemp? And then I invite the participants also to write their question in the Q&A part of the Zoom and in the chat.
I have one question which I would like to ask to Vicky Kemp. Thank you very much for your interesting presentation. I really like it. It's not the first presentation I hear by you, and what I like is digital approach. Let's do the digital tools. Let's create accessible, because this is the trend. That's where we are. Yeah, putting the tablet in police station is not such a big deal if it's equipped with the information which is accessible, easy. You push the button, you get the answer in the language you understand. Yeah, so this is a very interesting approach. What I would like to ask is related to this. The children, then they get this Bill of Rights, you know, that yeah, it's a document that people do not read. It's like this small letters that you get in the bank with your bank agreement, and you never take a note of it, right? Do you think that it could be maybe also worth if there is no possibility to have the tablet at the moment, or to have digital tools at the moment, maybe to have additional like Bill of Rights for children, the specialized one, maybe with examples, simplified language, maybe even, I don't know, some graphical design that could be used?
Yes, I think that would be a good idea. We have tried to do this in England and Wales, and that there is a child-friendly version. The trouble is that a lot of the development of these tools can be top down. And so I think the development of one tool by the police, which made a really good effort at this, but there's some assumptions within that. So that explaining, for example, the right to silence, there's a storyboard that basically says, if you don't say something in the police station, you'll be made to look like a liar in court. Now that's one interpretation, but you have a privilege against self-incrimination. And so the storyboard isn't telling you that side of things. It should really say, I think, don't say anything unless you speak to a lawyer, because this is so complicated. It's all well saying, well, you'll look like a lawyer if you get to court, but you probably won't get to court if the police don't have any evidence against you. So I think that I agree with you. I think there are ways in which we can have child-friendly materials. And I think working with my colleague Leslie Laver, we're looking to develop animations in these tools and passing them through children. And the comments that they come up with are really helpful. And I think it's really getting back to that sort of information. What information do they need? And the problem we have as researchers or practitioners is there's so much information that we need to give them. Well, let's just strip that out. What are the important messages? They're very vulnerable within this process. And so I think that, yes, we can use tools, but what are we actually trying to do with the tools? I don't think I can get anything child-friendly that will explain what the right of silence is. So really my question to government will be, why do you have a modified right of silence for children when I can't explain it? So I think it's important, but we shouldn't get into the trap of trying to put something into a child-friendly language that actually isn't child-friendly at all.
Thank you, Professor. So in the question and answer box, we have a testimony from a participant. It's not a question actually, but I want to read it because I'm quite amazed to see that we have people following the webinar from Indonesia. So the participant said it was, hi, I'm Ahmad Israel from University of Lampung in Indonesia. In developing countries, pressure is needed so that the government is serious about providing legal assistance so that children are not in detention. We have a program so that children get special treatment, especially those involved in crimes, but our prisons still has a lot of children in it. Thank you for your message, Ahmed. And I don't know how to say it in English, but good luck or congratulations for the work you do in Indonesia. It's crucial. I think does the participant have other questions, or the panelists? You still can write them in the question and answer box or in the chat. If you don't find the question and answer, I think you can write in the chat. I don't see other questions. So I think we can, maybe Vicky, you have something else to add, or not, or if not, we will go on the break, on the coffee break.
No, I don't. I was just very interested in hearing what Ton had to say, and I think there's a lot of these important issues coming together, and the work that you're doing in raising them is really important. And I think that, as Ton says, the role for a lawyer to have this holistic approach and the training and the understanding could be really quite essential. So thank you very much for inviting me today.
Thank you for participating. So we will go on a coffee break. We are sorry we're not inviting you for the coffee break. We would have loved to, but unfortunately this year it's not possible. So the coffee break is from now and until 2:25. And then we will have the second panel of the afternoon, and we will present you the result of the LHI research in Lithuania, Belgium, and Albania. So see you in more or less 15 minutes.